free of cost, and a 30% discount on upcoming events organized by Vidhigyata. Beside the top three performers, the other 10 performers, top 10 performers of the month will get an opportunity to publish one article on the Vidhigyata website free of cost. This is our way of recognizing, encouraging, and promoting exceptional drafting skills for the future lawyers. Now, I would like to welcome the Advocate Manas Mishra, sir, which will be your mentor for this entire civil drafting internship. He is a legal academic and researcher associated with the High Court of Allahabad, Lucknow bench. He holds an LLM degree in criminal law with minor in human rights from esteemed University of Dr. Hari Singh Gaur Vishwavidyalaya, Sagar, and a BBA LLB honors degree from MIT Law School, MIT University, Uttar Pradesh, Lucknow. His research interests include criminal jurisprudence, constitutional law, human rights, right to privacy, international constitutionalism, environmental sustainability, digital evidence, and sociological studies. He has authored and co-authored several research papers and book chapters published in UGC Care listed and peer-reviewed journals, and has presented papers at national and international seminars hosted by premier institutions including JNU, BHU, and central universities across India. From this, I think you will all be satisfied that you're in the hands of good advocate. He's also a member of review committee of the International Journal of Research and Analytical Reviews, short for IJRAR, and serves on the editorial board of the Center for Philosophical Inquiry, contributing to scholarly peer review and academic governance. He actively engages in academic discourse through research, conferences, and faculty development programs with a strong inclination towards interdisciplinary and policy oriented legal scholarship. Now, I will welcome Advocate Manas Mishra, sir. Sir, it's over to you now.
Uh, Thank you so much. The person I don't know the name. Thank you so
You
much,
can continue, sir.
Vishwajit. Okay, thank you so much for this wonderful introduction. Thank you so much, Team Vidhigyata and Ashutosh, for giving me this opportunity to deliver on such a wonderful topic, legal notice, and further the drafting of the same. Okay, just a second. Just give me 1 second, please. I hope I am audio visible. Hello.
Yes, sir.
Yes, okay. So, all participants are very welcomed here. Today, we are going to understand one of the most underestimated but very powerful tool in the law, the legal notice. So, before any case enters in the courtroom, there exists a stage which I prefer to call is anti-chamber of justice. Just like a waiting room before entering an important office, the legal system also has a some preparatory space where disputes are defined, clarified, and sometimes even these issues are resolved without any sort of litigation process. Any legal notice operates a legal notice that operates in this legal in this space. It is not a merely procedural formality, but it is a very, we can say that it's a strategic and a legal instrument that can determine whether a dispute will escalate into a litigation or it will end very peacefully by way of legal notice and certain kind of further process that takes place without any sort of litigation. So if it's very properly understood, a legal notice can save our time, cost, and judicial burden. That is the very purpose of the that when we start studying the civil procedure specifically. So these are the objectives. The end of justice is achieved by way of saving time, cost, and judicial burden. Please change the slide 2. Understanding, understanding how a dispute travels. In legal every legal conflict that begins in what we call is a private sphere, where some sort of issue between individual, between two parties, they have certain kind of disagreements, maybe over money, over property, over certain contractual obligations. So at this point, the issue is very informal, emotional, and very unstructured. So there is no involvement of active involvement of the court anywhere in this process. And here the most important, most crucial stage of legal notice comes into the picture. This stage serves as a bridge between the private conflict and public litigation. So through a legal notice, the issue is converted into a formal legal claim, which is expressed in a very precise legal language supported by facts and legal grounds. Most importantly, legal notice, what follows is that it follows the principles of natural justice. While studying the administrative law from in the beginning, we are taught the principles of natural justice. There are three principles that are associated with the same, and the principle that is followed in the legal notice, just legal notice process is the audi alteram partem, which simply means that no person should be condemned and unheard. Finally, if the issue remains unresolved, it enters into a public sphere, that is the litigation, the court of law, where the dispute becomes a matter for the formal adjudication governed by statutes like the Code of Civil Procedure and other certain legal statute associated with the substantive rights. Please change the slide number 3. Yes. A legal notice is, as we can see, there is a bridge between the two poles. There is a visual pictoriated here. So, what does this picture describe? This picture describes that a legal notice is a bridge between before the process of litigation. Imagine standing at the edge of a river. Once you cross the bridge, you enter the territory of litigation, which is time consuming, which is very costly, and there are some ray of hope by way of legal notice, which provides a formal, final opportunity to resolve the matter before taking that step, the step of the litigation. So at the same time, it acts as a final warning to the opposite parties that certain kind of legal consequences that are so imminent if corrective actions are not taken. So what does the legal notice performs? It performs a dual function. It invites some certain form of settlements some while also signaling some seriousness. This is why courts often look a legal notice as indicators of intent and good faith. Slide number 4. Yes. Legal notice sets into a motion what I usually prefer to call is trajectory of truth. Here we can see that with this pictorial presentation, a trajectory of truth, which has three stages one by one: communication, clarification, and the last one is the correction. First one is the communication. The aggrieved party formally informs the other party about the grievances by way of legal notice. One party who is suffering from certain kind of legal certain kind of complexities relating with the subject matter, and there are chances that certain kind of litigation, certain kind of legal issue that can take place in future. So it's better to communicate the opposite party about the situation and go for the settlement outside the court, which is not very hectic. So first, communication, the object of which is that to communicate the other party, the opposite party, about the matter in issue. This ensures that no one is taken by surprise in court. Suppose that the other person is not informed and plaint is filed before the court of law, so it does not make any sense. The other party uh, will not be having any chance to know about the case, what has happened, how it has happened. Further, we will see in a hypothetical case that team has provided about the NI Act. So this ensures that no one is surprised in the court. The other party is not surprised before the court after receiving any kind of summon. So second is the clarification. Once the notice is served, once the notice is sent, the facts and the claims becomes fixed. These facts and circumstances as have been claimed by the plaintiff in the notice cannot be altered. They cannot be easily changed. Their version cannot be changed later. Third aspect of this is the correction. The notice provides a window of time. Yeah. Those who are aware about the limitation of act, there are certain limitation as per the case and circumstances of the case to case. Certain limitations have been provided by the law, either by way of limitation act, either by way of any procedural law. For example, there are certain so many things that are provided in the civil procedure code also, supported by limitation act and for example NI act, consumer protection, etc. So third is the correction. A notice period provides a window of time, usually 15 to 60 days. That is normal time period, but it depends upon the facts and the statute that under which the legal issue involves. For the so this period is provided for the opposite party to rectify the mistake. So this stage is very extremely important because it allows disputes to be resolved without any judicial intervention. So we can say that legal notice is not merely a accusatory; it is a corrective in nature. Please change the slide. Yes. One of the most interesting aspect of a legal notice is that it has some psychological impact on judicial perception. Judges do not operate in vacuum. They assess the conduct of the parties. If the legal notice is sent and the defendant ignores it, the court may perceive the defendant as a unreasonable man, as a negligent man. And on the other hand, if no legal notice is sent at all, the plaintiff may appear aggressive as if they have rushed to court without giving other side a chance. However, if the notice leads to settlement, it reflects some positivity in the on the side, both sides. It reduces judicial burden. Therefore, a legal notice acts as a behavioral test. It reveals the attitude and the intention of the both sides even before the trial of any particular case begins or comes into the picture. Please change the slide. Yes. From this side, from this slide number 6, I hope we can understand a legal notice as an architectural blueprint of justice. It serves three major roles. First is that it acts as a sociological filter by eliminating weak or unnecessary cases, thereby reducing the burden of courts, as we have so far discussed. Second is that it acts as a certificate of good faith. It demonstrates that the plaintiff attempted to resolve the issue before the process of litigation begins. Third is that it serves as a tactical seed which helps in establishing the cause of action, defining the timeline, and quantifying the damages. In many cases, what happens is that the legal notice itself becomes a foundational document that saves the entire litigation strategy. Slide number 7. Yes. Now, it is very important to understand that in certain cases, sending a legal notice is not optional but mandatory. For example, when we are suing a government, so it can be sued under following the procedure of Section 80 of the Code of Civil Procedure, which requires a 2 month prior notice to be sent before concerned authorities are associated with the government of India or any other government. Similarly, if in a case of Section 138 NI Act check bounce case, check dishonor case, legal notice must be sent within 30 days, giving the drawer a 15 days time to make uh, payment. Without complying these requirements, the case itself fails. And in general cases, what happens that notice is always not mandatory, but it is strongly advisable to serve the notice as a matter of strategy and fairness. Slide number 8. Yes, from this balance, we can showcase that it is very essential to distinguish between a legal notice and a plaint. A legal notice is a pre-litigation document and is generally permanent in nature. You cannot easily amend or withdraw it. On the other hand, a plaint which is filed before the court of law, it can be easily amended under the procedural law by following the civil procedure code. So this makes the drafting of a legal notice extremely very critical. Any inconsistency between the legal notice and the plaint can be used during cross-examination to challenge the creditability of the plaintiff. Therefore, while a plaint is a procedural document, a legal notice is both. It has some strategic value, as well as it has some evidentiary value also. Please change the slide. Well drafted legal notice can be compared to a building as showcased in this slide. The foundation consists of fact which must be accurate and complete. The columns here represent the grievances, how the law has been violated. The archway here represents the relief sought, whether it's a payment of money, whether it's a performance of contract, whether it's a cessation of any act. So finally, it's the keystone is the deadline which specifies the time within which opposite party must respond. If any of these components are weak, the entire structure becomes unstable. So therefore, precision and clarity are essential in drafting. Slide number 10. Yes, here the theoretical part of notice is being concluded. So it can be said that a legal notice is not a letter. You are not drafting any letter. It's a very carefully crafted legal instrument. It represents or presents a truth in a structured and very compelling manner. It gives opposite party a clear choice: either comply with the law or face the legal consequences after the expiry of the time period. In many cases, a strong legal notice can resolve the dispute entirely, making litigation unnecessary. Therefore, we can say that legal notice is not merely a beginning of a litigation, it is one often half of the battle is won by way of legal notice. So now I request the team to showcase me the drafting they have prepared to understand the drafting of the legal notice. Yes. Should I start or wait for a few more minutes? Hello, team. Should I start?
Yes, sir.
Okay. So now, before we go into the drafting part of this legal notice, I want you all to imagine a situation that suppose you are a businessman and you sell goods worth rupees 4,75,000 to someone. Instead of paying cash, that person gives you a check. You trust the person and deposits the check in your bank. After a few days, you receive a message from the bank that the check has been dishonored due to insufficient funds. And at that moment, what would you do? Naturally, you would feel that you are cheated, you are frustrated, but the law does not allow you to immediately file a case. What the law requires is to follow a procedure that has been established by the specific law, specific procedure that has been laid down in the specific act under which that fact or that fact in issue is attracted. So at the first time, at the first and very most important step in the procedure is sending a legal notice. Without sending a proper legal notice, you cannot complain under section 138, for example, here in this case of the NI Act. Uh, so without a proper notice, any kind of complaint proceeded under section of 138 will not be maintainable before the court of law. So now let's understand the legal foundation. Section 138 of the NI Act on which this whole hypothetical case has been drafted makes a check dishonor, uh, which is a criminal offense under the law when the check is returned unpaid due to several reasons, for example, insufficient funds, as we have seen in the case, or if the drawer stops the payment. However, this offense is not automatic. The law provides an opportunity to the drawer of the check to make payment after receiving notice. Therefore, the payee must send a notice within 30 days. On receiving the information about the dishonor of the check, and the drawer must be given 15 days to make a payment. Only if the drawer fails to pay the amount within the 15 days that has been provided, uh, does the cause of action arise to file a criminal complaint. Now let us come to the drafting part. I will explain the draft given to you step by step, and I want you to not just understand what is written, but why it is written in the draft. So we begin with the heading portion of the notice. At the top, we can see that the name and details of the advocate has been written. This includes the name, designation, office address, and contact number. This is very important because the notice is generally sent by an advocate to give it a legal seriousness and authenticity. Otherwise, the opposite party will not will take any person who is not advocate for granted and will not respond accordingly, which is the objective. So when a person receives a notice from advocate, they understand that what the legal consequence, what the legal action may be followed if the needful is not completed. So below you will see that the mode of sending the notice by way of registered ADUPC. This is not means registered and acknowledged. It means this is not just a formality. This is a crucial evidence. So in code, you must prove that a notice was actually sent and received, registered, and it has been acknowledged by registered post, which helps to prove our case very efficiently. Just give me a moment. Please scroll the uh, page. Yes, yes. Okay. The date portion. Okay. Now the next important thing that we are supposed to deal here is the date. Date is extremely important because the entire limitation period is calculated on the basis of the date. What courts do, courts strictly the examine whether the notice was sent within the prescribed time period, within the following the limitation period provided by the law. Therefore, it ensures that the date, therefore, it's a duty of the advocate, a duty of the litigant is to ensure that the date which has been mentioned is correct. After that, we mention the details of the recipient. As we can see in the draft, the person to whom the notice is being sent, this includes the name and the complete address. If the address is incorrect or incomplete, the notice may not reach to the intended person, and the case may fall within the ambits of the technical terms. Then comes the subject line. Please change the slide. Scroll the, yes, the subject line. So in this draft, we can clearly see that the subject is that local legal notice under section 138 of the NI Act 1881. The subject line gives an immediate clarity about the nature of the notice. So what does it do? It helps the recipient to understand that this is not an ordinary communication, but a legal demand from the side of the plaintiff, as we can refer. Now we move to the main body of the notice, the first paragraph. The first paragraph usually begins with the standard legal phrase that under instruction from and on behalf of client. What does this line express is that it establishes that the advocate is acting on behalf of the client and has the authority to issue the notice. In this first paragraph of facts, we describe that what is the relationship between the parties. So here it is stated that the client is engaged in the business of supplying construction materials and the recipient purchased goods in the ordinary course of business. So this paragraph set up the background, and so it shows that there is some legitimate commercial transaction between the parties that has taken place on certain dates. In second paragraph, we have mentioned that the check about the check details. This includes the check number, date, amount, and the bank on which it was drawn. This is one of the most critical parts of the notice. The entire case under section 138 revolves around this check. Therefore, accuracy is very essential. Even a small mistake in check number or date can create a huge problem before the court. In third paragraph, we have stated that when a check was presented for encashment and through which bank, this is important because the law requires that the check must be presented within its validity period. This paragraph shows compliance with that requirement. Next paragraph, fourth paragraph, we have mentioned that the check was dishonored and state the reason given by the bank, such as fund insufficient. There was some deficiency of the funds in the account of the person to whom the notice has been served. So this is the core of the offense. Without dishonor, there is no offense under section 138. Next is paragraph number 5. We have mentioned that the client came to know about the dishonor of the check. This is again important for calculating the limitation period, as we have discussed for sending the notice. The law requires that notice must be sent within 30 days from the date of receiving information about the dishonor of the check. Next paragraph, paragraph number 6, we clearly state that the act of the recipient amounts to an offense under section 138. What is the important significance of this paragraph is that it gives a legal character to the facts stated earlier. It is not merely a narration of events; it is an assertion of legal liability that has already arisen, but certain future legal consequence that will not favoring the defendant may also arise. So next, finally, we have come to most important part of the notice, the demand clause. Here, the recipient is called upon to make the payment of the check within 15 days from the date of the recipient, from the date of the receipt of the notice. And this is the mandatory clause. If you fail to give this 15 days period, your notice becomes invalid and your case cannot be proceeded. Along with the demand, we also include a warning that if the payment is not made, legal proceeding will be initiated at the risk of the recipient. The notice ends with a formal closing, including the signature and the details of the advocate. Please keep on scrolling. There is also a line stating that a copy of a notice is retained in the office of our records. This is important for maintaining the evidence. So, dear participants, I want you to understand one thing very clearly, that drafting is not about using difficult English or complicated sentences. It is about clarity, precision, and legal correctness. Every word in a legal notice has some purpose. You are not writing any sort of story, any sort of narration, any sort of fiction or poetry. You are building a legal document that may be scrutinized in the court, and that is scrutinized in the court. We must have seen the movie Jolly LLB 1, 2, 3. So many sequels have been there. The judge identifies several mistakes in the drafting. So we are not supposed to be of that kind of advocates that we make such silly mistakes in before the court of law. That's not considered as a. It's not. It's a taboo on the professionalism. So always remember, a good legal notice is structured, precise, and fact-based. It follows the legal requirements strictly and avoids unnecessary language. Here I am concluding with the some small note, as the topic was very small. There were no so many things philosophically that it could have been covered. So I hope that today you have not only learned the format of a legal notice under section 138 of the NI Act, but also the reasoning behind each part of the draft. This understanding is crucial because in practice, drafting is one of the most important skill for lawyers in all of us. Thank you so much. For task number 2, you can proceed to your concerned guides that have been allotted by the Vidhigyata. Thank you so much.
Thank you very much, sir, for your valuable time and this knowledge. I assure you, sir, these are not the things which a law student can learn from classroom only. Because of your efforts and Vidhigyata, now these law students have this practical knowledge for which they would have to spend numerous hours in court. Now, before ending this session, I would like to bring to your attention of all the participants a very important info. Vidhigyata is going to organize all India level quiz competition on 15th of April. Just a minute, I will tell the. Yeah, here it is. Now, Vidhigyata is going to organize all India level quiz competition on Indian constitutional law. It is the second edition. We have organized the first edition in which more than 200 students participated. In this competition, there will be various exciting prizes for the top performers of this quiz. The first prize for the first ranker is 2000 rupees, along with the other prizes. The second ranker will be getting 1500 rupees cash prize, along with the other prizes. And the third ranker will be getting 100 rupees cash prize, along with the other gifts. Now, to bring to your attention that the participation fees of this quiz is 99 rupees, but just for today, its participation fees is 69 rupees. You can visit the Vidhigyata website for registration. And now the second thing, the most important one, an initiative took by Vidhigyata. We have created two PDFs for all the law students, which will be very beneficial for them Sorry for the inconvenience. I got left out by the meeting. Sorry. Here it is, the meeting. The preview of this PDF which we have created by Vidhigyata. Actually, this PDF is created to give you a complete roadmap for both 5-year law students and a 3-year law students. It tells you what you should focus on in each stage of your law school journey, from building basic legal skills to preparing for top internship and placement. Inside this PDF, there are two PDFs. In the first PDF, you will learn what to do in your first year, second year, third year, and beyond that, which skills law student must develop, when to start internships, how to build a strong CV, how to stand out from other law students, and what activities actually matter for your career. The second PDF includes a complete internship roadmap. It will tell you how to find internships, where to apply for the internships, and how many internships you should do and you must do for your legal career, and how to approach law firms and advocates, and what are the mistakes a law students makes while applying for the internship, and how you can refrain from doing those mistakes, and the template of cold emails to send to that firms where you want to do internship, and how to convert the most important thing, how to convert internship into a long term opportunity. So if you want to purchase this PDF, the link will be shared in the internship group, and from there you can purchase the PDF. Thank you for the today's session, and now you can leave the meeting. Thank you.